Hi, everyone, and welcome to episode 16th of Study with Me, European Union Law. This podcast helps you get ready for your university exams and gain a deeper understanding of the subject. Okay, so let's dive right in. We're looking at the very foundations of the European Union today, primary law. This is the core stuff, the constitutional bedrock, you could say, though as we'll see, maybe bedrock is a bit strong given how it can change.
Exactly. And for your exams, you absolutely need to get the hierarchy straight from the start. Primary law, it's the highest legal source, no question. It stands firmly above secondary law, all the regulations, directives, the day-to-day legal acts. Its job, really, is to set out the basic legal framework governing how everyone in the EU legal system relates to each other.
And it's not just about institutions talking to member states, is it? It goes much further. I mean, thinking back to Van Gandhi on Loose, that was huge. These treaties give rights and, importantly, impose obligations not just on governments or Brussels, but directly on individuals, too.
That direct effect, yes, that's absolutely crucial. It's what makes the system work, gives it real impact on the ground. And the ECJ itself, the Court of Justice, famously called the treaties the constitutional charter of a community based on the rule of law. So it was back in '86, the Verts case.
Constitutional charter, it sounds so permanent, so fundamental, almost like a national constitution. But you mentioned it's maybe more political language. What's the catch?
Well, the catch is their amendability. Unlike, say, the U.S. Constitution in some respects, the EU treaties can be changed in any part. The only condition, all the member states have to agree. So fundamentally, they still behave like international agreements. But here's the key insight for study. By calling it a charter, the court gives itself leeway. It allows for systematic and teleological interpretation, looking at the purpose to sometimes override a strictly literal reading.
Ah, okay. So that label, constitutional charter, it's a tool for the ECJ. It lets them interpret the treaties in a way that helps achieve the EU's goals, even if the text itself is super detailed, which isn't typical for constitutions usually. It allows the law to sort of evolve.
Precisely. It's about interpreting the text to maximize its effectiveness. It's a fait utile, as we'll discuss later.
Got it. So let's look at the structure then. We always hear about the TEU and the TFEU. If they're both primary law, why two treaties? Why not just one big one?
It's a deliberate structural split, but the number one thing to remember, academically speaking, is Article 1 of the TEU confirms they have the exact same legal value. Equal footing. The division is purely functional. No hierarchy between them.
Okay, equal value. So what are the different functions then? How do we tell them apart?
Think of the TEU, the Treaty on European Union. It's shorter, 55 articles, as the high-level statement. It lays out the fundamental values, the democratic principles, the main institutions, like in Articles 13 to 20. And crucially, the TEU is where you find the rules for the Common Foreign and Security Policy, the CFSP.
Right, and CFSP gets its own space there because it operates differently. It's not done through the usual community method. It's more state-to-state intergovernmental.
Exactly. It's a special case. Then you have the TFEU, the Treaty on the Functioning of the European Union. This one is the beast, over 360 articles. It's the detailed instruction manual. It defines specific powers, policies, how the union actually works internally. Think internal market, competition rules, social policy, environment. It's all laid out in this huge Part 3, union policies and internal actions.
Okay, TEU for the framework and big principles, TFEU for the operational details. But that's not all, is it? There are other bits attached. Protocols, declarations, what's their status?
Yes, very important not to forget those. Primary law also includes, currently, 37 protocols and 2 annexes. And Article 51 TEU is crystal clear. These protocols have the same primary legal value as the treaties themselves. They're not footnotes, they're integral parts. They're used for specific technical stuff like the rules for the European Central Bank, or sometimes for special arrangements for certain member states, like Denmark's opt-outs detailed in Protocol 22.
Same value as the treaties. Got it. And what about the declarations? There are quite a few of those too, like 65.
The declarations are different. Critically, they lack binding legal force. That's a key exam distinction. They aren't law. However, think of them like insights from the drafting process. Referencing the Vienna Convention on Treaties, they're useful interpretive aids. They show the context, the intentions of the states when they agreed the text.
Okay, so treaties plus protocols are the binding core. Declarations are helpful context. Right. Now, the really big question, how do you change this foundation? This seems like where the politics really bites. Article 48 TEU, right?
Exactly. And Article 48 is fascinating because it doesn't give just one way. It sets out 3 distinct procedures for amendment. Each one kind of reflects that ongoing tension, the EU needing to evolve versus member states wanting to keep ultimate control.
Okay, let's break them down. First up, the main one, the ordinary revision procedure. That's Article 48, paragraphs 2 to 5. When does this apply?
This is the default, the general procedure. It can be used for any kind of treaty change, big or small, no limits on scope. The process itself is quite involved. An initiative can come from the EU Parliament, the Commission, or any national government. It goes to the European Council, the heads of state or government via the Council of Ministers. The European Council then decides, just by simple majority, whether to even consider the proposed changes.
And if they say yes, what's the usual next step?
Usually they convene a convention. This is a big, broad gathering. You get representatives from national governments, national parliaments, the European Parliament, the Commission, sometimes even the ECB. The aim is for this convention to reach a recommendation by consensus. It's about building broad support.
Okay, so the convention debates and recommends. Then what? Does that recommendation become law?
No, not directly. The recommendation goes to an intergovernmental conference, an IGC. That's a more traditional diplomatic negotiation, just among the representatives of the member state governments. The IGC drafts the actual legal text of the amendments based on the convention's recommendation or perhaps modifying it.
So convention for broad input, IGC for the hard negotiating and drafting. But even after the IGC agrees on a text, it's still not done, is it?
Not at all. And this is the absolute core point reflecting state sovereignty. The amendments agreed at the IGC only enter into force if, and only if, they're ratified by all member states according to their own constitutional requirements, usually meaning parliamentary votes, sometimes referendums. Unanimity is key. Every single state has a veto through ratification. That's the ultimate sovereignty lock. There's a small provision if ratification gets stuck. If after 2 years, 4/5 have ratified, the issue goes back to the European Council, but it doesn't override the need for unanimity.
Wow. Okay, so unanimous ratification is the final hurdle. Is there a way to skip the convention part?
Yes, the European Council can decide, by simple majority, not to convene a convention if the changes aren't deemed that extensive. But they need the consent of the European Parliament to do that. Then it goes straight to the IGC.
Right. That's the ordinary procedure. Seems tough. What about the simplified procedures? There are two, right? Let's take the first one, Article 48, paragraph 6.
Okay, simplified procedure number 1, its use is strictly limited. It can only be used for amendments concerning Part 3 of the TFEU. So that's the bit with all the detailed internal policies, internal market, competition, social policy, etc. And crucially, you cannot use this procedure to increase the union's powers. It's for tweaking the existing mechanics, not expanding the scope of EU competence.
So fine-tuning internal policies only, how does it work? If it's simplified, what gets skipped?
It skips the convention and the IGC. Instead, the amendment is adopted by a unanimous decision of the European Council itself, after consulting the European Parliament and the Commission. So it still needs every head of state or government to agree, which is a high bar, but it avoids the lengthy convention and IGC process. Ratification by member states is also required here.
Okay, unanimous European Council decision, plus consultation, plus ratification, but limited scope.
Got it.
Now, the second simplified procedure, paragraph 7, this is the Passerelle or bridging clause. Sounds like it's about moving things along faster.
That's exactly the idea. Its purpose is specifically to allow a shift in decision-making rules within the existing treaties. It allows the European Council to decide unanimously that for a certain policy area currently requiring unanimity in the Council of Ministers, future decisions can be taken by qualified majority voting, QMV. Or it can allow a shift from a special legislative procedure to the ordinary legislative procedure, which increases the European Parliament's power. It's about making decision-making more, well, efficient.
Okay, moving from everyone needs to agree unanimity to a weighted majority, QMV. That sounds like a significant shift, potentially reducing a single country's veto power in day-to-day lawmaking. If it bypasses the IGC and national ratifications, where's the check?
This is where it gets interesting. There's no formal ratification by member states in the same way as the other procedures. The decision is taken by the European Council acting unanimously after getting consent from the European Parliament. So high-level political agreement is needed. But there's a crucial safety break: national parliaments. After the European Council adopts the decision, national parliaments have 6 months to examine it.
And what if they don't like it?
If even one single national parliament objects and notifies its opposition, the decision is dead. It cannot enter into force. So while it avoids the formal ratification process, it gives each national parliament an individual veto power over these specific institutional shifts.
A single parliamentary no stops it. That's a powerful check. Okay, we've covered the written treaties and how they change, but you mentioned earlier there's more to primary law, the unwritten stuff.
Yes, absolutely. For a full understanding, especially academically, you need to know that primary law also includes general principles of EU law. These are principles often developed by the Court of Justice, particularly in the early days, to fill gaps or ensure coherence. But they have the same status, the same hierarchical value as the treaties themselves. They function as guides for interpreting all EU law, and importantly, they act as benchmarks for the legality of secondary legislation. EU institutions and member states are bound by them.
Okay, same status as treaties. Can you give us a couple of key examples? What about loyal cooperation?
Loyal cooperation? Yes, it's fundamental. It's explicitly mentioned in Article 4 of the TEU now. It's not just a vague nicety. It's a real binding legal obligation, and it works both ways vertically between EU and member states, and horizontally between member states. States must take all appropriate measures to ensure treaty obligations are fulfilled. And, just as importantly, they must refrain from doing anything that could jeopardize achieving the union's objectives. It demands active commitment.
Okay, active commitment. And another one you mentioned earlier, effet utile. Effectiveness.
Effet utile, yes. This is a core principle of interpretation used constantly by the ECJ. It basically dictates that when you interpret an EU law provision, you must choose the interpretation that makes the rule achieve its intended purpose most effectively. The Adidas case is often cited. If a rule could be read in different ways, you prioritize the reading that actually makes the rule work and deliver its intended effect. Maximize the law's usefulness, you could say.
Right, interpret for maximum impact. Okay, let's do a quick recap for exam prep. We've got the treaties TEU and TFEU as the core constitutional charter, equal legal value. Protocols attached also have that primary value. Declarations don't. And changing this foundation is complex, governed by Article 48 with its three paths. Ordinary, Convention, IGC, unanimous ratification, simplified for TFEU Part 3, unanimous European Council, ratification, no competence change, and the Passerelle, unanimous European Council, EP consent, but a national parliament veto. Plus, don't forget the general principles like loyal cooperation and effet utile as part of primary law.
That sums it up well, and it brings us back to that interesting point. Why does the EU, this community based on the rule of law, stick with such complex, often slow, veto-ridden amendment procedures? I think it really underscores that despite the huge transfer of powers over the decades, the treaties are still, at their heart, international agreements. Their ultimate legitimacy and modification rest on the political will and the final say of the individual member states, particularly through ratification or, as we saw, parliamentary vetoes.
Which leads perfectly into a final thought for you, the listener, to ponder. Think about that Passerelle clause again, Article 48, Paragraph 7. It's designed to boost efficiency, to move towards QMV. Yet the fact that just one national parliament out of 27 can block such a shift, what does that really tell us about the balance between the drive for a more effective union and the enduring power of national sovereignty deep within the EU's legal structure? Something to reflect on. Good luck with your studies.